of LA early on, and they threatened every mental health director in the state of California with a lawsuit if they implemented. So after all that fighting to get the law, they finally realized, when counties started finally opting in, okay, we've lost that battle. And by the way, a representative from Disability Rights California has been at every oversight committee meeting over the last 5 years. I have never heard one complaint. So why in God's name were they fighting about it all those years and threatening lawsuits that we were trying to force treatment on people? Because once we got there and started really trying to help people, they have absolutely nothing to say. So positive or negative, they just sit there and take notes. We follow San Francisco's model, which was adding 30 days of, somebody mute yourself, please. So we were 30, can you still hear me?
Yeah.
I got sort of cut off. 30 days of outreach and engagement prior. That's the first thing that happens in San Francisco and in LA. They sort of wanted to document that we had met the concerns of the statute, that somebody had been offered voluntary care multiple times and had been unable to engage or refused to engage. So they do 30 days, not more than 90 days of outreach and engagement. And again, our teams are out there on the street trying to help people, mainly who are homeless. And at the end of the 90 days, they will then do a review with the court and decide whether to drop the case, refer for LPS conservatorship, or get the client to sign a voluntary settlement agreement, or subpoena the client to come to court to discuss the direct court order from the judge. So that's sort of been our process. But the best thing about assisted outpatient treatment, everybody was so concerned about getting clients to agree and that they would be sort of maneuvered or coerced into treatment. I'll tell you where the coercion is. It's on the system to not walk away from people. And that's something that Carla taught me, because it binds, if you have to go to report to the judge on every case. So we have teams all the time. They outreach to a guy 3 times, 4 times, 5. At some point they walk away and they say, this guy doesn't need help. The numbers in Los Angeles are so overwhelming. It's like, okay, next we'll go on to the next guy. We'll offer the next guy treatment, or the next woman treatment. But when you have to go back to the judge and say, this person, there was an application and a petition, and we started working on this case, you have to go back to a judge and explain why you're dropping this person, or why they don't meet criteria, or whether we were unable to get them and we couldn't get them into court for whatever it is. It binds the Department of Mental Health to the client, and that, I think, is one of the most important things. So you had something you want to add?
Yeah, well, no, I just wanted to get some other folks an opportunity to chat, but yeah, you're absolutely right. I think we do lose sight of the fact that this is it's not just to hold the individual accountable to their treatment plan, but the treatment team to serve
right.
the individual. Absolutely. So one thing both Mark and Janet mentioned, that they kind of said, they got everybody to the table and everybody came. I know a lot of communities, that's where they run into that initially, is just getting everybody to the table. And it sounds like that wasn't really a big barrier for you all. I just wonder, are other folks running into that problem, just the difficulty of getting the right people to the table just to have the conversation? Just curious if anyone wants to bring that up, or if somebody had that problem and was able to do something out of the box to try and get folks to the table that really weren't engaged. And just thought I'd throw that out there, because I know that's an issue for some of you who are earlier in the process. Anybody struggle with that?
Sure. Oh, I was just going to say, feel free to unmute yourself or raise your hand. So go ahead.
All right. So as you three already know, we are working on AOT implementation in the Great Rivers region of Washington. So it's basically the southwest corner. And in Washington state, they already have, AOT falls under the Involuntary Treatment Act. And so they already have other types of least restrictive alternatives that are currently being used. And basically AOT would expand the length of the order, who can be placed on it and who can petition, to try to capture more of those individuals who are close to meeting criteria for hospital, but not quite. So in my experience so far, I've done outreach and education to the court system with the 3 counties that have the ITA courts. However, after that initial engagement, I've been having a tough time getting back to the table. The court, a lot of the individuals at the courts are saying, you know, they're already close to capacity, even though my agency will be funding the additional court costs. And some of the individuals like public defense and a couple of the prosecutors are just not returning my calls or emails. So I feel like I'm, you know, knocking on the door, peeking in the windows, trying to engage through a lot of different avenues, using colleagues who might know individuals, but I'm still having a lot of issues engaging. And so I, you know, have talked to the implementation team at TAC, and we'll be getting support through them as well, as far as trying to, you know, connect to other judges who might be able to come and talk to this region. But yeah, it has felt a bit defeating in some ways, just getting the right stakeholders to the table.
Yeah, I mean, a lot of judges don't understand it. You know, they just don't have their arms around it. It's, you know, the mental health has a lot of nuances. If you're not part of the mental health community, it's really outside of their realm of experience. Our judges here in the state, with the help of TAC, have created a training program for judges, and TAC spent quite a bit of time on it. And so some really, really expert judges like Judge Stephen Manley from Santa Clara County have actually been going around the state and doing Zoom trainings on AOT, you know, trying to get the judges, new judges, comfortable with it. Because, yeah, I want to do this. I'm a mental health court judge. I'm involved in collaborative courts and treatment courts, but I really don't know what I'm doing. This is really brand new. And a lot of them have to learn the local system to get what resources are going to be linked to the court. You know, so that's sort of free flowing, but you need the buy-in. But, you know, as far as I'm concerned, the outcomes for these folks, if they don't get into treatment of some kind, are so catastrophic. They're either going to deal with them in criminal court, or you're going to deal with them in AOT court. You know, but you're going to deal with these folks anyway. So you're not sweeping a problem under the rug. You're just changing rugs. You know?
Exactly.
They're still, and they're just going to cost more money, and they just don't understand that. And you know, our experience, I mean, a lot of people walk away, but we've helped hundreds and hundreds of people in Los Angeles that have been on streets for a decade, you know, or more, you know, years and years and years. And the experience has been similar to New York. You know, about half the people that we really engage with end up in the program, you know, but we've also been able to get people into an LPS conservatorship when AOT wasn't a high enough level of care. So I hope that helps.
Yeah, thank you for that insight. You know, I feel like, you know, with all of these systems overburdened as they are and everybody running around ragged, I feel like a lot of people are more in this reactionary mode where the caseloads are already so high. There's not enough staffing at agencies, you know, the courts, you know, have a lot on their plate as well. And I feel like when I present, you know, this change or this shift within the system, it can feel overwhelming to individuals. And like, how can we take on one more thing? But, you know, like I said, looking long-term, the benefits are huge for communities. And so I think it's looking past that short-term, how is this going to increase my workload, and looking at the overall effect that it can have.
I mean, there's so many
Also, if I
people
can-
being
oh, sorry, Mark.
just a last point, I'll give it up to you, Janet. If you're discharging somebody from jail who's got a history of repeated hospitalizations or repeated lack of engagement with the mental health system, what's going to be your best option? Releasing and discharging that person to an AOT team who can then you bring in your best professionals to work with that individual, or just treating them. If somebody's coming out of a hospital who is a high utilizer of hospitalization services in your county, why aren't we discharging that person to the AOT team? It's just common sense. And I still haven't been able to get that to happen enough in Los Angeles, but we're working on it. But I think that's the argument. Go ahead, Janet.
I see
Yeah.
Kate's got her hand up too. So go ahead, Janet, and then we'll turn it over to
Oh.
Kate.
I was just going to say, it's really difficult to start something new. And I mean, we have that problem in New Orleans too, where especially in the courts, not enough staff. We're also short police. Everybody's understaffed, underpaid. And I mean, it's just like trying to get something new happening it's really hard. It's a heavy lift. So what I do is I'm not one to I do everything backwards. I start and then I build the system behind me, right? Or, I build the system as we go. So sort of building the plane as we fly it. And so like today we filed, I have a little bit of funding for legal services for people, free legal services for people that can't afford attorneys now. And so we were able to file a petition in a neighboring parish that does not have an AOT program. I mean, they're aware of AOT. They did apply for a grant, but they didn't get the grant. And so it's not happening really. And I get a ton of referrals from this parish because they're so close. I mean, you don't even know. I mean, they're so close that you wouldn't know when you crossed over the dividing line that you were in a different parish. And so today we did file a petition for an individual while he was hospitalized. A mother contacted me while he was hospitalized. We got the petition filed. And in doing that, because he was in a hospital, we were able to get the evidence that we needed to move forward with this particular case. I won't get into the details of that, but we tried the system. So we have a law. The law allows anybody to file a petition. Anybody in the state of Louisiana can file a petition anywhere in any court in any parish in Louisiana. Now, not all parishes have programs, obviously, and so without a program, it's difficult to get AOT to work. So it's a little risky, but we did it today. And basically I called the mental health authority and I said, well, the law requires that you be there. And I called the provider and it's like, he was already with this provider. I said, well, you got to be in court on this day. We need you to testify that services are available and will be provided. The attorneys were there. The judge, I got a hold of the judge, law clerk, and I said, okay, you got this petition that's been filed. And here's the thing. I don't know if this judge has ever done an AOT hearing before, but here's what you need to know, right? So I'm like highlighting areas in the law and I'm like, this is how it's going to go. Here's the directive. This is what the judge needs to know. And we all came to court this morning and it was fantastic. I mean, it could not have gone better. And the mental health authorities like, we need to be doing more of these. And so, now because they've done one and they see how it works and they see how easy it is and the coordination that's happening. And of course I'm there and there's oversight and monitoring and supervision and the judge is loving it. Like he doesn't want to be the AOT judge, but he's just loving this process. So, I just, I kind of will, if I can't get the buy-in that I need in order to get something happening, I'll go outside of the system and I will just figure out a way to do it anyway. And I'll force them. So I'm like forcing the system.
Yeah.
And usually people come around unless people are forced to start, they just won't start.
Yeah, that's awesome story.
Yeah, thank you for sharing that. I know Betsy had mentioned something around that last time we had chatted, and it got me thinking of more creative ways to get engagement from the courts and from the community. And so, yeah, I really like that approach. If we're having difficulty in engaging in other ways, just bring it straight to the court. Since it is written in law in Washington too, anyone can apply at any court. So we're only doing a disservice to the community if we don't have those workflows in place.
Great. Kate, you've had your hand up.
Yes, so I'm in Michigan. Actually, I'm in northern Michigan. Michigan has some really good AOT rules, but like many of you, the judges and probably our older judges are more problematic with not understanding AOTs and taking advantage of them. But similar to, I guess, Louisiana, anyone can file one. You don't need an attorney. We are fortunate. We have a judge, Milt Mack, who does similar trainings to what Mark Gale was talking about. He has done trainings for judges throughout the state, and then he's done trainings for family members. And then he has kind of been collaborating with Wayne State University, and they have developed AOT toolkits and webinars specific for judges, for hospital workers, for law enforcement, for community mental health, and for like family members. So I highly recommend going to Wayne State University and looking at what they have. And Judge Milt Mack, my guess is, because he's always so helpful, that if any other judge from another state wanted any of the tools or slideshows or anything that he has been using, that he'd be happy to share. But our community mental health is probably, at least up in northern Michigan, one of the slowest partners, because they haven't developed a program. They don't have an AOT director, but we're working on that. So all in all, though, all the other players are starting to really get it. So we're, in a good place, I think. Thanks.
Yeah, Kate, I'd love to connect with you. Maybe if you could, or if maybe you could share your email just to learn more about how to connect with Wayne State and get additional resources and maybe share with community partners. That'd be great.
Yep, I'll put it in the chat, Mandy.
Okay.
Anybody else have something they want to add or problem they're encountering they wanted to talk through?
Yes, this is Edmund Creekmore. Can you hear me?
Yes.
Yes, I was intrigued by the gentleman who is involved in the AOT courts in Greater Los Angeles. We in Virginia also have issues with disability rights people who insist that a court process has to be voluntary. I'm intrigued. I've heard so much about care courts and wondering if, since they are a civil court process, that as I'm understanding it, anyone can be referred to, as some of the participants have talked about in other states. But the homeless person, a person with, most of these are, as I'm understanding in the Care Courts Act, are seriously mentally ill or have a serious neuropsychiatric condition. It's a voluntary process to the extent that they have insight and participate in care courts. How do those two legal processes parallel each other? One of them being voluntary, one of them being largely involuntary, or where you have in many states with AOT, we call it MOT in Virginia, they may decline to participate, have the ability, but if they're court ordered and they have the ability now under our statutes, our AOT, MOT statute, they can be required to participate. How does the care court parallel as a voluntary process that largely involuntary population in AOT and Landris Petrus Short?
Lanterman Petrus Short. It's a great question. And there are differences, but I'll highlight them real quick. So number one, our AOT statute, I don't know about other AOT statutes around the country, but in California, you have to have been either in a hospital or jail at least 2 times prior in the last 36 months, or you had to committed an act of violence or threat or attempt of violence in the last 4 years prior to the new petition. So that's the target population, really. And there's 9 criteria in the law, but that's the population that's being targeted, which is different because in care court, they're basically targeting people who have psychotic illnesses, people who suffer from psychosis. So that's one of the big differences. I will take issue where people say, well, AOT is an involuntary program. I got to tell you, we write very, very few direct court orders where a judge, sort of mandates or compels treatment. I would say 95% of everybody is signing a voluntary settlement agreement and agreeing to help, because what you get is really intensive outreach and really intensive case management. And that's what we've got good clinicians. And if they do their job right, they're talking people into engaging in treatment. We do write some court orders, but it's really very few. So in the end, it's more of an intensive voluntary program, even though there is an involuntary component. And in California, you got the direct court order. Somebody comes in, is subpoenaed. They come into court to face the judge. So let's say they say to the judge, disability rights used to ask Judge Anderson from Nevada County, which is where Laura lived, which this is Laura's law. And I remember at a conference, there was a consumer who started yelling at him and say, well, what do you do if they say no? And Judge Anderson looked at him and said, well, we talked to them and we keep talking to them, and eventually they comply. Now, in our law, we have a stipulation. If the person does say no, the judge does everything he can do to convince the person to engage in treatment. What's left is under 5346 of our Welfare and Institution Code, person can be referred for evaluation in an acute inpatient hospital for a 5150 hold, 72-hour hold. Once the person is referred to a hospital for evaluation, AOT is over and our LPS statute, our involuntary commitment statute, takes over. So, and a lot of people who say, well, it doesn't have enough teeth. That's the teeth that we have. We had our poison pills in our legislation too when the bill was passed. But the counties have been opting in because what they're seeing is results. People are getting help. But frankly, there is very little involuntary direct court orders written by judges in the state of California. It really mostly ends up being voluntary, where they sign a settlement agreement.
Could I pursue that just a bit further?
Sure.
You know what?
Yeah.
You know what? I would, let's take that part offline, because by definition, we see that AOT is court ordered treatment, and that a court order is necessary by definition. California has their own process, and they're trying to remedy that with care court by using court orders up front instead of having this. California is different. Prior to last year, you couldn't do step down from a hospital into AOT. You couldn't. Now there's a law that says you can, but they're not using it. And 90% of MOTs or across the country are step down. So we can connect you two and you can have a conversation about this.
I put my email in the chat if anybody has questions.
Perfect. Thank you.
Curious, does anybody, so we've got some seasoned folks on the call here, and then we have some new folks. I'm just curious, if any of the new folks have a question or something, a problem you're running into, or need some advice. This might be an opportunity to throw it out there. Or if even one of the folks that have been at this for a while have some kind of something you've done, a trick up your sleeve that you've not shared yet that's helped propel your program forward, we'd love to hear that too.
This is Tiffany with Pathways. While the concept isn't new to us, it's new in the fact that we really haven't had a whole lot of these to have to manage. So I think it would be helpful to us to have a smaller group discussion, maybe with just a few of you, to help us get off the ground and let us figure out what the next steps are. We talked about this in the executive team yesterday, and they had lots of questions. So I think that would help us more at this point, if that's able to be done. And I would like our attorney, in-house attorney, to be involved in that. He had lots of questions.
Absolutely, Tiffany. We're happy to help coordinate that with you.
Thank you.
Brooke, I wonder, Brooke, if you could put our email link into the body there. It's just our general box that anyone can reach out to us if you want to ask us a question offline or schedule time to meet with us. We're happy to do that with anybody.
And Tiffany, I don't know if you looked in the chat. I responded to you so that you could set up a meeting.
I haven't, but I will.
That's great.
Thank you.
Sure.
I think one story I'd like to share, if it's okay, and just to also reemphasize the power of the court as a coordinating body that can enforce continuity of care. We're really finding that, in our parish anyway, the left hand often doesn't know what the right hand is doing. Inpatient psychiatrists don't talk to outpatient psychiatrists. Persons going through the hospital system and being discharged with instructions to take their medication and follow up with their outpatient provider once they've been discharged. Of course, they never do that. And one of the things that we've been able to do is just really provide that, as they say, double-sided tape to make sure that the respondents are sticking to the system and vice versa. But we have interesting situations come up that the judge can get involved in and to help problem solve. And that's kind of my favorite part about AOT, because we can innovate things that haven't been done before. And one issue came up with a respondent who had been hospitalized, discharged to the family. It was a hesitant discharge because we weren't sure how he was going to do. Sure enough, began decompensating. It was a struggle to get him back into the hospital. But before that happened, one of the problems we were having was the family were telling one story, that the individual was discharged from the hospital and was doing great. And then the ACT team didn't follow up quickly enough, and he wasn't getting his medications and started to decomp. And the ACT team were telling another side of the story, and nobody really knew exactly who was telling the right story. And so at one of we have check-ins every 2 weeks, probably should be every week, but we only have one judge and it's not a specialty court. So we do what we can. But at one of the check-ins, we brainstormed together that the solution to this problem was to have the inpatient psychiatrist talk to the outpatient psychiatrist. So we had an order. We got an order. We have an attorney who acts as the curator for the court, and the attorney was ordered by the judge to drop an order to have the doctors talk to each other and find out where the disconnect was and what the medication regime was when he was discharged and what he's on now, because we just didn't, nobody knew. And so that happened. The doctors talked to each other, and from that meeting that they had with each other, the hospital got super excited about AOT, and now we're all going for lunch. We're all talking together, inpatient, outpatient psychiatrists, or, shaking hands, and there's like warm handoffs happening now and all kinds of stuff like that. And it's, for a minute they were mad at us, and I was like, well, wait a minute, who ordered you to talk to each other? So y'all are ganging up on us, but you wouldn't be talking to each other if we hadn't ordered you to talk to each other. So anyway, it was that part of the story was a happy ending. The individual's still in the hospital, and it's a tough case. But that's just like the power of the court. What a judge can do. Judges can do stuff, and people respond to judges. And I mean, really, the reason that I went to a judge to start the program was because I knew that if he called the meeting, everybody would come to the meeting. Had I called a meeting, Actually, I did do the first little bit, but I partnered with one of the biggest mental health authorities in the state, and that gave me some leverage. But when you partner with an important person and you get them to agree, you know, to whatever it is you're trying to do, whether it's an educational series or starting a court or whatever, you know, usually folks will come. If someone important tells people to come to a meeting, they usually will come. If you're not important enough, they probably won't come. So I just like attach myself to important people and make them do stuff. That's how I get stuff done. So it's really me running it. I mean, I'm running the show, but you know, they pretty much do just what I tell them to do, but that's okay. I don't care. Whatever works, right? Where there's a will, there's a way. And no is not a word in my vocabulary. So,
yeah, that is good advice. I know sometimes when it's the judge with jurisdiction, that's the problem, that won't come to the table. Sometimes we even go to another judge in that same you know, county, if it's a judge with a mental health court or a drug court who's kind of already bought into the whole therapeutic jurisprudence concept. Sometimes we'll ask them to be the one to call the meeting and invite its colleague or her colleague, and that works too. But you're absolutely right. Getting an invitation, it's hard to turn down an invitation from a judge for sure. Let's see. Who else would like to chime in? Tiffany, I think you put a couple of questions in the chat box. Do you want to just go ahead and ask those questions, or are those ones you want to wait till we have them take offline?
Oh, it doesn't matter either way. I'm not sure how you guys are doing on time. It's fine either way.
So you're asking about the question about a program. That sounds like a good question. What's your question?
Well, I said in the note here that working with IT for all these years has taught me to you know, really pay attention to the words I use, and so words sometimes mean different things to them. So when the word program is used, is that used for like a specific treatment modality or milieu, or like we have a special sequence of events that happens in IOP?
Right.
Or does that mean the treatment team gets together and we decide, okay, Betsy, you know, based on what we feel like clinically is happening, this is kind of where we feel like that would help you best. You have X amount of individuals, groups, or peer support, medication management, however. I just wondered how that worked.
It's a great question, and one that we hear frequently. When we use the term program, we're not using as we're using it to distinguish between just using court orders, so as a procedure. So a lot of communities will just take somebody who's been, you know, involuntarily hospitalized and place them under a court order to follow through with treatment, but they don't do anything with it. They don't monitor that. There's no, you know, there's no wraparound service. There's no treatment program collaborating with the court to, you know, monitor and provide support and to make sure that that individual is adhering to their treatment plan, and if not, that they have some mechanism to you know, to hold them accountable. And so when we say a program, we're talking about the systems kind of collaborating to work together to make this, help this person be successful. But we've discovered too, by using the word program, we turn a lot of people off, because especially now with staff shortages, a lot of communities are saying, oh, well, we don't have the resources to start a new program, so we can't do it. And it really is a misnomer, because it really isn't that big. It's not a huge lift. They don't have to, the services are already available in the community. It's not like they have to create new services. It's really just a, you know, folks sitting around, you know, getting together and figuring out how they're going to collaborate for this particular population of people. It doesn't require a great deal more than that, other than just changing how they communicate. And doing that monitoring aspect of it. So we've been trying to come up with a different word that doesn't turn people off, and we haven't been successful yet.
No, program doesn't turn me off at all. Everything you say, we already do and monitor. We monitor everything. So that's not a problem to add. I think our biggest, from what I've heard so far, our biggest challenge at Pathways is probably going to be getting the judicial system involved. We have some great relationships that we've already cultivated, and then some that are just not there at all. So that's going to be probably a challenge. And so what I anticipate is for us to roll that out probably in the counties that we do have those relationships and have that worked out well, and then have those people help us target the other folks in our counties that we may not be serving.
That makes a lot of sense.
Our attorney had asked yesterday if I live in Boyd County, so if the consumer lives in Boyd County, can a judge in Greenup County, if that's the judge that we work with and he or she is great, can they sign the petition for the Boyd County person?
I mean,
No.
in all likelihood, no.
And the judge
Okay.
isn't typically the petitioner, so, it
Oh, I
would
know.
be,
Right.
it would be somebody else that would file the petition, and then, like in our parish or our state, the law says that the petition has to be filed in the parish where the person is found or believed to be present.
Right.
Now, I will say that needs to be clarified, because what we're finding is we have people who are so they go into the hospital on an involuntary hold, and then if they meet criteria for a bed, if that hospital doesn't have a bed, they will transfer to an area hospital that might be outside of our parish. And it's becoming a huge problem for a family to petition for someone who lives in our parish but is hospitalized somewhere else. So maybe that's just unique, for us, but it's definitely something to watch out for in your laws, that, if it says that and you're looking to do amendments, you would want to clarify that if the person resides in the parish, that despite what hospital that they're getting, where they're receiving treatment, that the petition can be filed in that parish where they reside. So that's something, and really it shouldn't be a problem. However, the respondent's attorney in our particular area is sticky about that, and it drives me crazy because he's not sticky about other things, and he wants to see his clients get help. He won't interfere if they aren't looking to fight AOT. He will not say anything, but on this issue, for whatever reason, he's just, no, I won't agree. So it's a real problem.
Yeah, so if your question is, can a judge order somebody into AOT that does not reside in that county, as Janet said, yeah, very unlikely.
Right.
Unless they
They could transfer.
Some judges have regions, where they have more.
But for Kentucky, I know it's that way for the 202As. We do them all the time, but for the outpatient stuff, we just didn't know if that was a possibility that would make it easier if it was, but I just don't know that.
They could transfer. So like, for instance, if somebody's found in our parish that lives in another parish, but they're found in our parish, and the judge executes the judgment in our parish, once that person leaves to go wherever they're going to go, we can transfer the order to any court in the state. So it was just kind of like a lateral transfer. So the clerk would it would be clerk to clerk. But as far as the law, it's the law stipulation, it is the petition has to be filed where the person is found.
And there are a lot of places that have that issue because of the size of county. There's not a hospital in every county. But the other thing that can happen is that one of the good things about COVID, it has shown us that we can do pretty much anything remotely. And so some jurisdictions actually hold their AOT courts virtually. So the county of residence holds the hearing virtually, and the hospital, the doctor, the participant can participate, and the court order stays in the county of residence. So you can do it both ways. Transfer the court order like Janet suggested, or have the county of residence be the original holder of the court order.
And we do that, Amy. We have a hybrid court, so we use Zoom and in person. So that, especially for doctors who are busy and they're rounding, you know, they don't want to bother with writing a report to court and testifying, you know, we make it so that they can Zoom in for like 5 or 10 minutes, give their testimony, and they don't have to leave the hospital. And so they love that. We get a lot more buy-in because of that.
Others on the call have something they want to bring up? We've got a lot of wisdom in this room. I'd like to hear from you.
But if no one else wants to jump in, could I pursue just one more aspect of what the gentleman was talking about in Los Angeles? Is concerning the two unsuccessful court orders, petitions before the patient is ordered into AOT or MOT. Are there any states that allow, that do away with that two unsuccessful court petitions or hospitalizations as a condition for court ordering AOT?
There are a number of states where that's in statute, and it's not unsuccessful court orders, it's previous hospitalizations. And they could be voluntary hospitalizations or not. But I mean, that's in New York statute, that's in a good number of state statutes, actually.
Hospitalizations or jailings.
Right.
Well, in Virginia, if the person comes up for a petition 2 or more times, as I'm understanding our 37.2817, then they can be court ordered. That is an option.
I think, and I think that's hospitalization. So yeah, if they're hospitalized involuntarily 2 times, then they could be petitioned for outpatient MOT.
Yes.
Right. And I believe it, Amy, the statute says they have to have received treatment in the hospital
Right,
to legally qualify as a hospitalization.
right.
So are there any programs that do away with that requirement where a patient could be court ordered on a voluntary basis? That's what I wanted to ask about in Virginia, because we're looking at the possibility of giving the judge discretion of a judicial stay of an AOT order, where the patient, if they have capacity, could work with the doctor in the community under a stay of a judicial order, where the judge would check in every once in a while and a review or status review in the community, but where the patient could fashion their own care through supported decision-making, case management, or possibly shared case management model. Is there any state that does anything like that? I thought that's why I was intrigued by care courts, because they seem to have certain elements of that. And
There's nothing about a court order that prevents a treatment provider from engaging in shared or supported decision-making. We really believe that a court order, that AOT is foundational to recovery, because it really identifies those who can't participate in recovery in their current state because of their psychosis. So, I mean, that's what the court order is for.
but isn't that only for the seriously mentally ill patients that I mean, the 50%, according to tax statistics, have insight and capacity. About 60% of bipolar diagnosed patients. So why wouldn't there be an option where they could it still be? I mean, I believe in the power of the black robe here. You know, they don't literally wear black robes in the psychiatric hospital I'm an independent examiner in, but you know, why couldn't that be still under the indirect supervision of the judge? He would review to see if the patient is following the voluntary order, but it wouldn't be AOT itself. It would be a stay of an AOT order. If the patient were non-compliant, non-adherent, had to come back after failing to follow their own care plan that they devised with the supporters in the community, then you could re-implement, reinstitute an AOT order. That's what we're looking at.
Yeah, I think that, again, this would be a better conversation for us to have offline, and happy to do that. If you look in the chat, Brooke put in the Brooke Gentry, not just any, put in our how to schedule with us.
I hope I did it correctly. I saw a date. I clicked on that and I just saw a box for the time, and there was a space to put in a time, but I didn't see where you click it to enter that, to actually.
You should just be able to click the time and that'll schedule it. You
Right,
can't,
so
you
just
can't
put the-
enter a time, you just click the time, because the times available are the only times that we are available. So let's move on to Kate, because she has another question.
So
Or-
I have kind of a unique situation because we've had an AOT for our youngest son who is 35. And in the past, it didn't really work. Our CMH, there were a number of reasons, but so we filed another one. He was picked up and taken to the hospital emergency department for an assessment. In our form in Michigan, you can ask for the AOT plus inpatient, or inpatient only. It's all in the same form. In that case, I had asked for inpatient plus AOT, and the psychiatrist who came to assess him said that, actually, I may have just asked for inpatient, but anyway, he said he did not qualify for inpatient care. And so when the court held the hearing, our probate court, that was denied. And I should have put either inpatient, I should have checked both boxes, inpatient or AOT, so that once the psychiatrist said he doesn't qualify, and part of the reason I think is, he's obviously on Medicaid and there's not enough beds. And even though he's been in and out of jail because of his mental illness, he had been recently back in jail, and he's also shown signs of violence. All the things were there, all the signs were there, but he wasn't like raving off the charts when he was in the emergency department, right? So we all know that scenario where the person has this huge history and they have current actions that indicate they need care, and yet at the time they're assessed, they're not presenting. But anyway, because they said, no, he doesn't need inpatient care, now I have nothing. And if I don't know how the other states do this, but if I had perhaps put inpatient care as my first choice, or the combination is my first choice, and if not, then AOT, because for AOT, we need a psychiatrist's assessment or the psychiatrist to testify at the hearing. So has anybody seen anything or done anything like that?
I can say
Does that make sense?
Yeah. What we do, So we don't do this as part of the AOT law, but what my organization will do is I work with families for people who need longer term hospitalization, and we make AOT a criteria of discharge. So we can put that into the judicial commitment order, that once the person is discharged, that they will be receive, or that they will participate in AOT. And if the family is, if they have the resources, they typically will interdict as well. And that's a great combo, like a long-term commitment with an interdiction, and then mandated to participate in involuntary outpatient when discharged it's a winning combo usually. Problem is that most families can't afford it.
Thanks.
But we don't have anything in the AOT law that does that kind of dual, have to have. It's ideal. We would hope that would be happening anyway. But you're right, it doesn't have, that's the problem. It is a problem.
Kate, when we passed the AOT law in Ohio, a lot of families thought, oh, now this is our opportunity. We can just file a petition while our loved one's still in the community before, to prevent them from, intervene earlier so they don't go to the hospital or don't go to jail. And that was kind of what families were all set to do. But then we discovered it's much more difficult to get them in there because they're not in treatment. So you don't have that medical testimony. So what we've done is we've changed our advocacy. In Ohio, we will tell families, when your loved one is in the hospital, talk with the doctor and ask the doctor to file the petition. So instead of, waiting for them to come out of the hospital and then trying to prevent them from going back in, let's get them while they're in the hospital. They're stable.
Yep.
You've got the doctor's testimony. You have everything you need. Then that's when you should be filing. So there's a little bit of a shift in terms of, how we educate families around AOT. Don't wait till they're
Yep.
discharged.
And we may have, our jail may now have a part-time psychiatrist. So next time he ends up in jail, I'm hoping to contact law enforcement and ask them to get that psychiatrist in there in the jail and do an assessment.
So the way we did it is person can file a petition while the individual is outpatient, even if they're symptomatic. And then typically they end up they're always going to be going, they go back to the hospital. We pretty much know that that's going to happen when they get hospitalized. In the order, in the petition, the attorney will write in an order for a order for a court-appointed psychiatrist to evaluate the individual while they're hospitalized for the AOT program to see if they meet criteria. And so that works really well. That's how we get our evidence. But we removed that part of the law that said they had to have the evaluation before the petition was filed. Now what they can do, but family can file a petition pro se with no evidence. The only criteria is that the individual, we have to have facts in the matter. And what we're looking for is that they have a history of treatment non-adherence. They don't even have to have had previous hospitalizations. And then once the petition is filed, then if they go to the hospital, then we get our court, we get the court appointed psychiatrist to eval. And then when they get discharged, even if they're not discharged, we can have the hearing while they're in the hospital by Zoom or once they get discharged. But we encourage the hospitals to hang on to them until they get stable. Now, I will say the hospitals do not like that. When we first started doing it, they were like, you can't have another psychiatrist come into our hospital and evaluate my patient. And we're like, doc, they're not evaluating your patient to treat your patient. They're evaluating your patient just like they would for competency restoration in a criminal proceeding. They're just evaluating to see if they meet legal criteria. And if they don't, and if the hospital refuses, then they're in contempt of court. So we're like, well, we just want to remind you that if you don't allow us to evaluate your patient, then you're in contempt of the judge. So I use the judge. I throw him around all the time. It's like, I'm sorry, but it's the law. It's a judge. Judge ordered it. So that's how we get our evidence. Most of the cases are done that way, and we have great relationships with all our doctors now.
Are your filer petitioners able to ask for a second psychiatric opinion if the first one says no, they don't need AOT? No.
No, but I've never heard, really, the only time that we've had evaluations that by a doctor where the person didn't meet criteria for AOT, it was because they needed a higher level of care. it was never that, oh, they don't need AOT and they don't need a higher level of care. They just don't meet criteria. It's never that. It's always either AOT or a higher level of care. We've never, ever had anyone evaluated where they said they didn't need involuntary commitment of some sort. Outpatient.
Thanks.
Okay. Well, we're about a quarter after 4 here, so this maybe we have time for one more question and then maybe just wrap this up. Anybody have something burning they want to share or ask? This has been a great exchange. Janet, thank you so much, and Mark for your expertise and sharing your wisdom with us. That was really helpful.
My pleasure. Thanks for
Absolutely.
the opportunity.
Well, thanks. I'll never hesitate to reach out if you have questions in between. Otherwise, look, we'll do this again in about 4 months. Amy, any last words of wisdom?
Nope, but we can always be reached at AOT@treatmentadvocacycenter.org. So that's it. Thanks
Well,
for a great
thanks.
conversation.
Thanks, everybody.
Thank you. Bye.
Everyone, have a great day.